My name is Golnaz Yazdhci. I'm a trust and estates lawyer in Los Angeles at Sheppard, Mullin, Richter, and Hampton, and I'm here today to talk about wills. People often wonder, what is a will? Do I need a will? What happens if I don't have a will? These are all very important questions and things to think about and consider, even though they may not necessarily be the most exciting topics or things that people want to think about, because it has to do with what happens after you die. But as we all know, as much as we plan during our lifetimes, it's just as important to plan for our deaths. Now, what is a will? A will is a legal document that gives instructions on what is to happen primarily with your assets after your death. In your will, you can name beneficiaries, and beneficiaries are the people that will receive assets from your estate after taxes or debts or anything like that are paid, who will ultimately receive your property. Those are your beneficiaries that you name in your will. It is also important to name somebody that's going to be managing the estate and making those dispositions and handling your affairs. That's called an executor. A will is one of many documents that may form an estate plan. An estate plan can consist of a will, a living trust, a power of attorney, and other documents concerning your healthcare desires. But if nothing else, it is recommended that you at a minimum have a will so that there is some direction as to how you want your property disposed of at your death. People also ask, who should be the executor? Is this someone that has to be trained in a specific way? Does it have to be a particular relationship with you? And the answer is no. You can name anyone to be your executor. However, there are a few good things to keep in mind. Being an executor means you're the person that's responsible for carrying out all of the instructions under the will and typically petitioning the court for probate to have the will admitted and to make all of the final dispositions. So it can be a very time-consuming job, and you want to choose someone that you trust, someone that you believe will carry out your intentions, someone that is organized, prudent, and honest. Many people, if they have a spouse or a partner or a registered domestic partner, will name that individual. Other people may name a child. There are also professional fiduciaries or corporate trustees that serve in this role. And anyone that serves as an executor may be entitled to compensation that's set forth under the law for certain things. You know, the person that does it, you want to make sure that they're responsible and equipped to handle the job, and also know that this is a big job, so they will also be compensated appropriately. If you have minor children, you may also designate in your will who you want to care for them if you and the other child's parent dies. So you can nominate a guardian for their personal well-being, for their personal affairs, as well as for handling their assets, which would include whatever you may be giving them at your death. You can name that person and give instructions in your will. Oftentimes it may be done by a separate document, but you can also do that in your will. There are essentially 3 different kinds of wills. Currently in California, a will has to be a hard document, a piece of paper that spells out your instructions, but there are 3 different wills. The first one we call a holographic will or a handwritten will. And there are a lot of very specific requirements for wills that you have to keep in mind, which is why it's always a good idea to consult with a qualified estate planning lawyer. If you want to write your own will, it should be in your own handwriting, signed by you, and dated. And make sure to have all of these components that we've been talking about. It does not have to be witnessed if it is in your own handwriting. Of course, you want to make sure that it's legible and easy to follow and understand. There's also something called a statutory will. That is this very simple form that the California State Bar has put together. You can access it online through the California State Bar website, and it's a fill-in form where you can put your preferences based on what's set forth there. It's very simple, so if you wanted to customize your will and be more specific about your instructions, you may not be able to do so with that form as it is currently on the website. And lastly, what I would say is the best option is to have an attorney drafted will where it is customized. You can indicate what your wishes are. You can be advised as to what may be the best course of action, and it would be typewritten. It must be signed by you, and it must be witnessed by two people that are not going to be receiving gifts under your will. So two disinterested witnesses. Nevertheless, even if you have a trust, you should still have a will, and we call that type of will a pour-over will. Because in that pour-over will, you can say, anything that I may have in my name that I haven't transferred to my trust will go to my trust and be administered as part of my trust and disposed of based on the instructions in my trust. Can you change or revoke your will? Yes, until you've died. It's always a good idea to revisit your will every few years or when your circumstances in life have changed. If you get married, if you have children, if there is a death of someone that you've named, it's always good to make changes to your will. You can do so by what's called a codicil. That's a very simple amendment to your will. Or you can revoke your will and do a whole new will.